Are you the father of a child with a woman that you didn't marry, and now you're wondering what you can file in court to make sure that you can still exercise your parental rights to your child so that you can spend time with them and help raise them as their father? There's something you can do to accomplish that. My name's Patrick Slaughter. I'm with LaFevor and Slaughter. We get dads that call us all the time that say, hey, mother's threatening to not let me see my child, or I'd just like something that was more regular and wasn't just up to her. Without a doubt, we tell them that they need to file an action to establish parentage and to establish a parenting plan. These are actually two separate legal actions, but you can file them together. It's interesting because in some counties in Tennessee, they make you prove one thing like parentage over on one side of a court, and the parenting plan action with custody over on another side of a different court. Knox County Juvenile Court is an example of that. But you don't have to go just to juvenile court. If there hasn't been a previous custody action in juvenile court, you could file it in chancery court or circuit court for that matter. But what you want to do is you want to go to court to say, Judge, I want you to establish legally that I am the father and provide me with all the responsibilities and privileges that that entails. The responsibilities are going to be, in a nutshell, you're going to be obligated to support your child or pay child support. The privileges are going to be you're going to get to spend time with your child in a designated manner that's delineated in a parenting plan. So you go to the judge and you say, I want you to establish that I'm the dad. I'm happy to pay child support. I just want to spend regular time with my child, so I need you to establish a parenting plan as well. And judges will do that. But to establish that parenting plan, they're going to look at what's in the child's best interest, not yours, not the child's mother, but what kind of parenting arrangement would be in the best interest of the child. And there's a way that that's happened, and I talk about that in some other videos. But you want some help with this, and I would tell you you don't want to go this alone. You'd like to hire an attorney, whether it's me or someone else. The reason is different judges in the state have different opinions and, predilections when it comes to what type or what default parenting situation should exist. And if you find a competent attorney that can help you, they can try to make sure that your case is filed in front of a judge or a court that's more likely to accommodate what you're attempting to accomplish. It's kind of hard to do these things on your own, but you can. Don't misunderstand me. You absolutely do not have to hire an attorney. You can try this on your own. It's not easy, but it can be done. But whatever you do, I think you need to take steps to make sure that happens, because if you don't, until there's a parentage order and a parenting plan in place, the mother is free to take the child and do as she pleases, which includes relocate or prevent you from ever seeing your child. Also, the longer you take to file such an action to establish a parenting plan, judges can tend to take it as, well, you weren't really that interested in spending that much time because you waited until the child was 15 years old before you came to me. So the sooner the better, but it's never too late. If I can help you, again, I'm happy to do so. Pick up the phone, give us a call, we can talk about it. But whatever you do, take an action, make things right before you don't have the opportunity to do that.